Alright, let me start by introducing this paper. It is paper 2 data response from May-June 2016, question 1. Okay, and it is a set paper 2 set 3. Alright, so firstly, let us just start off by going through the whole question one time. So sub-question A, Alan keeps 8 race horses in a field next to a busy road. He knows they can become very nervous in bad weather. A storm is forecast, and Alan sees a part of the fence is broken, so he ties some wood against the fence to make it stronger and plans to fix it properly the next day. That night, the storm frightens the horses. They run through the broken fence onto the road, and as a result, Pat crashes his car, causing £5,000 damage in his vehicle. Explain whether Pat can rely on the Animals Act 1971 in this situation. Sub-question B. Bernard buys his 15-year-old son Harry a venomous snake from South America. Bernard tells Harry he must always put his snake away in its tank, but Harry likes to have the snake on his bed when he is getting ready for school. One day, Harry is late for school and he runs out without putting the snake away. 2 hours later, Carol, the cleaner, goes into Harry's bedroom and is bitten by the snake. Explain whether Carol can rely on the Animals Act 1971 in this situation. Sub-question C. Keith has a guard dog which he lets run loose in the garden. A sign on the gate says, "Keep out and don't disturb me, I bite." Keith's brother Derek used to come round nearly every day and he always stroked the dog. The dog becomes more aggressive, so Keith decided to sell it. Derek was at Keith's house to say goodbye to the dog when it bit him badly on the arm. Explain whether Derek can rely on the Animals Act 1971 in this situation. Right, so because the purpose of this video is for me to just go through the data response part of the question, so I will leave out question D altogether. Alright, so the next important part is to actually look at the source material. Right, so source material for question 1, Animals Act 1971. Section 2, subsection 1, where any damage is caused by an animal which belongs to a dangerous species, any person who is a keeper of the animal is liable for the damage except as otherwise provided by this Act. Sub 2, where damage is caused by an animal which does not belong to a dangerous species, a keeper of the animal is liable for the damage except as otherwise provided by this Act if sub A, the damage is of a kind which the animal, unless restrained, was likely to cause, or which, if caused by the animal, was likely to be severe. Sub B, the likelihood of the damage or of its being severe was due to characteristics of the animal which are not normally found in animals of the same species or are not normally so found except at particular times or in particular circumstances. And sub C, those characteristics were known to that keeper or were at any time known to a person who at that time had charge of the animal as that keeper's servant, or where that keeper is the head of the household, were known to another keeper of the animal who is a member of that household and under the age of 16. Section 5, sub 1, a person is not liable under section 2 for any damage which is due wholly to the fault of the person suffering it. Sub 2, a person is not liable under section 2 of this Act for any damage suffered by a person who has voluntarily accepted the risk thereof. Section 6, sub 2, a dangerous species is a species, sub A, which is not commonly domesticated in the British Islands, sub B, whose fully grown animals normally have such characteristics that they are likely, unless restrained, to cause severe damage or that any damage they may cause is likely to be severe. Sub 3. A person is a keeper of an animal if Sub A. He owns the animal or has it in his possession, or Sub B. He is the head of a household of which a member under the age of 16 owns the animal or has it in his possession. Right, now that we are done with the sections under Animals Act 1971, now there's one case here. Cummings versus Granger 1977. An untrained Alsatian dog ran loose in a scrap yard to deter intruders. The dog seriously injured the plaintiff who had entered the yard. Held. Section 2 Sub 2 Animals Act 1971 was satisfied, but the defendant was entitled to rely upon the trespasser defense provided by Section 5. The dog had characteristics not normally found in Alsatian dogs except in circumstances where they are used as guard dogs. These were particular circumstances within Section 2 Sub 2 Sub B. Such an animal was behaving dangerously, but doing so in a manner characteristic of its species in the circumstances. Alright, let me start by introducing this paper. It is Paper 2 Data Response from May-June 2016, question 1. Okay, and it is a Paper 2 Set 3. Alright, so firstly, let us just start off by going through the whole question one time. So sub-question A, Alan keeps 8 race horses in a field next to a busy road. He knows they can become very nervous in bad weather. A storm is forecast, and Alan sees a part of the fence is broken, so he ties some wood against the fence to make it stronger and plans to fix it properly the next day. That night, the storm frightens the horses. They run through the broken fence onto the road, and as a result, Pat crashes his car, causing 5,000 pounds damage in his vehicle. Explain whether Pat can rely on the Animals Act 1971 in this situation. Sub-question B. Bernard buys his 15-year-old son Harry a venomous snake from South America. Bernard tells Harry he must always put his snake away in its tank, but Harry likes to have the snake on his bed when he is getting ready for school. One day, Harry is late for school and he runs out without putting the snake away. 2 hours later, Carol, the cleaner, goes into Harry's bedroom and is bitten by the snake. Explain whether Carol can rely on the Animals Act 1971 in this situation. Sub-question C. Keith has a guard dog which he lets run loose in the garden. A sign on the gate says, "Keep out and don't disturb me, I bite." Keith's brother Derek used to come round nearly every day and he always stroked the dog. The dog becomes more aggressive, so Keith decided to sell it. Derek was at Keith's house to say goodbye to the dog when it bit him badly on the arm. Explain whether Derek can rely on the Animals Act 1971 in this situation. Right, so because the purpose of this video is for me to just go through the data response part of the question, so I will leave out question D altogether. Alright, so the next important part is to actually look at the source material. Right, so source material for question 1, Animals Act 1971. Section 2, subsection 1, where any damage is caused by an animal which belongs to a dangerous species, any person who is a keeper of the animal is liable for the damage except as otherwise provided by this Act. Sub 2, where damage is caused by an animal which does not belong to a dangerous species, a keeper of the animal is liable for the damage except as otherwise provided by this Act if Sub A, the damage is of a kind which the animal, unless restrained, was likely to cause, or which, if caused by the animal, was likely to be severe. Sub B. The likelihood of the damage or of its being severe was due to characteristics of the animal which are not normally found in animals of the same species, or are not normally so found except at particular times or in particular circumstances. And sub C. Those characteristics were known to that keeper, or were at any time known to a person who at that time had charge of the animal as that keeper's servant, or where that keeper is the head of the household, were known to another keeper of the animal who is a member of that household and under the age of 16. Section 5, Sub 1. A person is not liable under Section 2 for any damage which is due wholly to the fault of the person suffering it. Sub 2. A person is not liable under Section 2 of this Act for any damage suffered by a person who has voluntarily accepted the risk thereof. Section 6. Sub 2. A dangerous species is a species, Sub A, which is not commonly domesticated in the British Islands. Sub B, whose fully grown animals normally have such characteristics that they are likely, unless restrained, to cause severe damage, or that any damage they may cause is likely to be severe. Sub 3. A person is a keeper of an animal if Sub A, he owns the animal or has it in his possession, or Sub B, he is the head of a household of which a member under the age of 16 owns the animal or has it in his possession. Right, now that we are done with the sections under Animals Act 1971, now there's one case here. Cummings versus Granger 1977. An untrained Alsatian dog ran loose in a scrap yard to deter intruders. The dog seriously injured the plaintiff who had entered the yard. Held. Section 2 Sub 2 Animals Act 1971 was satisfied, but the defendant was entitled to rely upon the trespasser defense provided by Section 5. The dog had characteristics not normally found in Alsatian dogs except in circumstances where they are used as guard dogs. These were particular circumstances within Section 2 Sub 2 Sub B. Such an animal was behaving dangerously, but doing so in a manner characteristic of its species in the circumstances. Alright, now that we have gone through the whole question the first time, and especially the source material, we can now attempt to answer the question. So the first thing that we should do while answering specific sub-questions is to actually highlight the issues or the important keywords or key points within individual subsections and how it relates to the source material in order to answer the question. So in sub-question A, the parties here are Alan and Pat, and the main issue is the fact that Pat crashed the car, causing £5,000 damage to his vehicle. Alright, so that is the first issue here. Okay, and of course the whole thing is due to the fact that storm frightened the horses and then they ran through and broke the fence onto the road. But before that, we should also highlight the fact that Alan keeps these horses next to a busy road, and he knows that the horses can become very nervous during bad weather, and because that night there was a forecast of a storm. Alan sees a fence that is broken and tries to tie the wood against the fence to make it stronger, but only plans to fix it the next day. And it is due to all these things in the beginning that is why Pat crashes his car, causing £5,000 damage to his vehicle. So now the question is asking us whether or not Pat can rely on the Animals Act 1971 to help him in this situation. Basically is to help him to see whether or not he can claim this amount of money, the £5,000, from Alan. And of course, firstly we have to establish, according to the Animals Act 1971, whether or not Alan is responsible. Okay, So the first thing to look at is actually in, of course, Animals Act 1971 section 2. Section 2 sub 1, the important part here is where it says damage is caused by animals which belongs to a dangerous species, and so therefore the keeper is liable. And sub 2, same thing, damage caused by an animal which does not belong to a dangerous species. And of course, same thing, keeper of the animal is liable for the damage. So now that we've highlighted these 2 points here, we can now determine that the relevant subsection to highlight or to apply into the situation is in subsection 2. Because why? There is a possibility to say that the racehorses are actually not considered as dangerous species. One way to actually reinforce that point is to actually look at this thing here in section 6 sub 2 regarding the definition of dangerous species. And generally it says that it is an animal which is not commonly domesticated in the British Islands. For horses, I would say they are domesticated in the British Islands. And next is the fact that these animals normally have characteristics that they are likely to cause severe damage. So horses, race horses generally, they are generally gentle animals, right? Do not have the characteristics of causing severe damage. So this thing is actually satisfied. Even though section 2 sub 2 already tells us what it means by animals that do not belong to a dangerous species, and racehorses pretty obvious already that they are not dangerous species, it would actually be good to actually highlight section 6 sub 2 as well, because it is a direct contrast to section 2 sub 2, and so therefore it is definitely something that we should actually highlight. Okay, right. Now the next thing is regarding this thing that a keeper of the animal is liable for damage. So who is the keeper? Alan. One thing that we should highlight is of course also section 6 sub 3, because here it defines who is the keeper, and sub A says that he owns the animal or has it in his possession. So pretty obvious already, because if you look at the facts itself, it says that Alan keeps 8 racehorses, so he is the keeper. No issue there. But again, same thing, it is definitely something, even though it is a small issue only, okay, that you should actually highlight it as well. Alright, now that we have highlighted that fact, we should now look at sub A, B and C, because here it says that the keeper of the animal is liable for the damage if these things are satisfied. So firstly, sub A, the important part here is damage unless restrained, and also severe damage. So when you apply this thing to the facts, there is definitely damage already, because why? It caused Pat to crash his car, causing 5,000 pound damage to his vehicle. So therefore there is damage, and it is definitely severe. Now the next part is regarding this thing here, unless restrained. Here it says that if the animals are restrained, then it is possible to say that the keeper is not liable. Right? So here, are the horses restrained or not? What we know is this part here, the important part, that the fence were broken and that Alan tried to fix it but didn't fix it properly, decided to only fix it the next day. So here I would say that sub A is satisfied already, to say that Alan is responsible. Right, so next part, sub B, the important part is likelihood of damage or of its being severe was due to characteristics of the animal which are not normally found in that animal or in their particular circumstances. So here, characteristics, right? What we know about horses is that they become nervous in bad weather, and that the storm frightened the horses, and because of that they ran through and broke the fence and onto the road. So this is the characteristic of the horses. Because of the fact that the horses are startled or frightened by the storm, is it possible to say that it is a particular characteristic which not normally found in this animal? Because if it's not normally found in the particular animal, it is possible again to say that the keeper is liable. Here I would say that generally, whether it's horses or any other animal, generally would be frightened by what we call the storms. But to what extent we do not know. However, here, in order to continue on with the answer, we should just assume that particular characteristic, being nervous during stormy weather, okay, it is something which is not normally found within such animals. Next part is sub C, and the important part in sub C is just this thing here, that those characteristics were known to the keeper. So if the characteristic that is not normally found in that particular animal, if it's known to the keeper, then it is possible again to say that the keeper is actually liable to the damage. So in that situation, if we look back at the scenario, we can see that he knows that they can become nervous in bad weather. So the fact that Alan knows that the animals, the racehorses, can become nervous in bad weather, he knows about their particular characteristics, and so therefore should actually be more responsible. So in a sense, you can say that the only thing here that can actually make Alan responsible is actually this part here and also this part here. Alright, because well, he knows about them being nervous, and the fact that they are nervous, that they have these particular characteristics, and also the fact that Alan didn't actually fix the thing properly. Right, so these two things alone would actually make Alan responsible already. Okay, and also the fact that well, it caused damage to the car. Question sub B. In this question, the first thing that we should take note of is firstly Carol, the person who is injured and would now like to use the Animals Act 1971 against potential defendants. And here it seems that there might actually be two defendants, as in firstly it is Harry and secondly Bernard. Right? However, in order to determine whether or not it is either Harry or Bernard who will ultimately be liable towards Carol, we have to actually look at what actually transpired. Firstly, one important thing that we should first take note of is that Harry is Bernard's 15-year-old son. And the next thing is regarding the fact that the snake, right, it is a venomous snake from South America, and the snake is apparently outside of the tank, even though usually Bernard tells Harry that he must actually put away the snake in the tank. But then, you know, as usual, he likes to keep it outside of the tank when he's getting ready for school. And for some reason, because he's late, he runs out without actually putting away the snake. So this part here is the important part. And later on, Carol, the cleaner, goes into Harry's bedroom and is bitten by that snake because the snake is outside of its tank. Right, so generally just these few things that are important that we should highlight. Right, now that we have taken note of the key points and also the important things within the scenario itself, it will be good to actually now look at the source material and see which part is actually relevant. So similarly, using the Animals Act 1971, it is good to start off with section 2 first. And in section 2, you got subsection 1 and 2. And as we have gone through the first time already, we already know that 1 concerns damage done by animals that are considered to be dangerous species. And in this situation, the keeper will actually be liable. And the other one is sub 2, where it does not belong to a dangerous species. Here, obviously, because of the fact that it is a venomous snake from South America, then definitely this can safely come under subsection 1 rather than 2. And so therefore, in order to continue with this answer, we need to now look at section 6 sub 2. Section 6 sub 2 now becomes more important for this question as it concerns a dangerous species. And of course, sub A, which is not commonly domesticated in the British Islands. This is very relevant and should definitely be highlighted because it is a venomous snake from South America. Secondly, sub B, fully grown animals normally have such characteristics that are likely, unless restrained, to cause severe damage. Alright, so in this situation, fully grown, according to the facts, we are not sure if the snake is fully grown or not. However, we can safely assume that it is fully grown. Otherwise, it won't be able to actually bite Carol. Alright, so yeah, fully grown animals. Okay, this whole thing here is important. Unless restrained. Alright, this is also definitely very important because of the fact that the snake definitely wasn't restrained, because the snake was supposed to be put in the tank, but it was apparently outside of the tank, and so therefore wasn't restrained. And yes, it did cause severe damage. So no problem here. You can definitely establish that there is some liability going on under the Animals Act 1971. And now the next question is Harry or Bernard the one who is responsible towards what has happened here? Because Harry the son is the one who is responsible towards the snake, and Bernard is the one who bought the snake for Harry, the 15-year-old son. So here, section 6 subsection 3 will become relevant already regarding the question on who is the actual keeper of the animal. So firstly, in sub A, he owns the animal or has possession of it. This is important. And secondly, sub B, he is the head of the household, of which a member under the age of 16 owns the animal or has it in his possession. This here is very relevant to the situation, as Bernard is obviously the head of the household and Harry is the 15-year-old son. And so if we were to follow this thing here, section 6 sub 3 sub B, Bernard will be the one who is responsible, as he is considered to be as the keeper of the animal rather than Harry, the 15-year-old son. Okay, so we've established that Bernard is the actual defendant rather than Harry. Now, the other issue is with regards to the cleaner being bitten by the snake. If we were to just leave it as that, meaning to say that we just look at section 2 sub 1 and section 6 sub 2 and sub B, then we are missing out another very important thing, which is in section 5 here. Right, so in section 5, the important thing here to be noted is the fact that a person is not liable under section 2 if the damage which is due wholly to the fault of the person suffering it. Meaning to say that the question now is whether or not this Carol is actually the one responsible for being beaten herself. After all, she went into the room to clean the room because she's the cleaner, and then she got bitten by the snake. And secondly, sub 2, a person is not liable under section 2 for any damage suffered by the person who has voluntarily accepted the risk thereof. Right, so important here. So the question now is, did Carol, the cleaner, actually voluntarily accepted the risk of the damage suffered? If we were to look at it as it is, as in according to the facts, there's really nothing to suggest that she actually voluntarily accepted the risk of being injured by the snake. And it would be preposterous to also say that because she voluntarily goes into the room to clean the room, because she's the cleaner, and so therefore she voluntarily accepted the risk to actually be bitten by the snake. So if you were to have that kind of mindset regarding this issue, this section 5 here, and also regarding issue here, then your answer is definitely wrong. Okay, because this is not just about common sense, but you must also understand how examination questions actually work. If, for example, that the scenario didn't even say anything about whether or not she voluntarily accepted the risk of being injured, then definitely you can assume that she didn't voluntarily accept the risk of being injured. A hypothetical situation or a scenario for a question will be something like this: that the Carol, okay, say for example that it is known that the snake is somewhere in the room, and she has been warned by Bernard or even by Harry, it doesn't matter, and yet she says that it's okay, and then she would go in and clean the room anyway. And if that is a fact in the scenario itself, then definitely this part here, section 5, will work in Bernard's favor. But because the scenario didn't explicitly say that she has voluntarily accepted the risk of being injured, so therefore this part here will not help Bernard at all. However, does it mean that we should leave section 5 out completely? Definitely not, because there is a reason why section 5 is here, for you to put it inside the answer. But of course, putting it in there to contrast the situation here. So even though it doesn't actually help you to get to a conclusion, but it is still relevant. This is how examination questions actually work. You can see it as a trick question, sort of, that they put in information such as these to confuse you, the examination candidate, and so therefore you, right, the examination candidate, need to actually get more experience in doing examination questions, especially for this kind of scenario-based questions. This is actually the same. I mean, this concept is actually the same whether it is for your paper 2 data response questions, or your paper 3 and paper 4 prompt-based scenario question, or for any other law paper regarding prompt-based scenario questions. So therefore, this is just one of the things that I want to highlight to you, and one of the things that you should really take note of when you are actually answering prompt-based scenario question. Because if you were to use section 5 to help Carol, and then say that Carol won't be able to claim anything from Bernard because of the injury, then your answer will definitely be wrong. So that's about it for this question B. Now, let's look at sub-question C. Here, the parties are Keith and Derek. Keith is the owner of the guard dog, so therefore he is the defendant, and Derek is the one who got bitten, and so therefore he is considered as the claimant. So in order to find out whether or not Derek can actually rely on the Animals Act 1971 to sue Keith, we have to point out some of the important key points within the whole scenario itself. Firstly, we should know that the guard dog, is let to run loose in the garden. And the next thing to note is that a sign is stated at the gate there saying that keep out and don't disturb me, I bite. Derek, who comes around nearly every day, always to stroke the dog. And as the dog became more aggressive, okay, this is the important part here, Keith decided to sell it. Actually, this part regarding comes in nearly every day to stroke the dog is also important, because it shows that he's probably aware of what is going on with the dog, especially when later on the dog became more aggressive to an extent where Keith had to sell the dog. And eventually, on his last visit, this Derek got bitten. So these are the only important parts regarding the scenario, and now we have to look at the source material to see which part of the source material is relevant to help either Derek or Keith. Right, so firstly, section 2 again. It's important that we keep on mentioning section 2, because section 2 of the Animals Act 1971 basically firstly tells you the difference between dangerous species and also non-dangerous species. So here, because it's a guard dog as opposed to a snake like in the previous question, we can safely say that it is a non-dangerous species. And again, we can actually highlight this part here, just like in sub-question A regarding the difference between dangerous and non-dangerous species. And similarly, things like this, not commonly domesticated in British Islands. Guard dog, we do not know what exactly it is, but most likely it is domesticated in the British Island, unless, again, like I say, that it specifically says that it doesn't belong in the British Islands. For example, like in a previous question, it specifically says venomous snake from South America, and so therefore very obvious in sub-question B that it is definitely not domesticated in the British Islands, right, as opposed to the guard dog in sub-question C. So the next thing to point out is section 6 subsection 3 regarding the keeper of the animal, and subsection A should be enough to satisfy the situation to establish that Keith is the owner or the keeper of the guard dog. Alright, so no issue there. However, the next issue is regarding subsections A, B, and C here. Alright, as even if the species is considered to be non-dangerous species, the keeper of the animal is also liable if A, B, and C is actually satisfied. So the first thing is regarding damage, unless restrained, and also severe. And here, similar to sub-question A, definitely there was damage. Here, definitely not restrained at all. As for severity, it can be safely said that Derek is badly beaten, and so therefore, yes, this is also satisfied. So subsection A is satisfied, no problem there, right? Now subsection B and C, just like in sub-question A, they are both related, meaning the likelihood of damage due to the characteristic that is not normally found, and that whether or not those characteristics are known to the keeper. So in this particular situation, if we were to apply to the scenario, because the dog has become more aggressive, so therefore most likely it is characteristics which is not normally found. Because if it's normally found, then I'm sure that this Keith would not actually want to sell off the dog. So it must have been pretty bad. It will be considered as abnormal, a characteristic which is abnormal. That is why this Keith would decide to actually sell off the dog. And another thing is that since Keith is looking to sell off the dog already, it should have been obvious that he knows about the characteristics, and yet he allows, here we can assume that the dog is still allowed to be run loose. The reason why I'm assuming this is because nowhere in the scenario actually states otherwise. So I guess we can safely assume that the dog is still running around. If the question wants us to address the fact that the dog isn't running around anymore, then it would have stated in the scenario itself. But because that issue is not actually stated at all, we can safely assume that the dog is probably still running around. So you can say that ABC is also satisfied already. Okay. However, there is one last thing here regarding this part here, to say goodbye to the dog. Alright, and this part here now relates to section 5 regarding the fact that the damage, that the person is not liable when it is the fault. The damage is due to the fault of the person suffering it. And also sub 2, not liable when the damage is suffered by the person who voluntarily accepted the risk of the injury. Right here again, it didn't say whether or not he actually voluntarily accepted the risk of being harmed, but because it should have been a fact already that the dog is becoming more aggressive and that kid is going to sell it off already, and yet this Derek still has the nerve to come to say goodbye to it and assumingly must have stroked the dog as well. So here we can safely assume that he has voluntarily accepted the risk of getting harmed. You see, this part here, especially this part here, is very much different from the Carol situation. Because in the Carol situation, it didn't say that she has actually voluntarily accepted the fact that she will be bitten. After all, she doesn't even know that the snake is there. As opposed to the Keith and Derek situation, the dog is there. Derek always come in to stroke the dog, and it's also a fact that the dog is becoming more aggressive to the extent where Keith is going to sell the dog. So therefore here it can be safely assumed that section 5 is satisfied. Right, so disregarding this section 2 sub 2 ABCD, section 5 will still come in to actually help Keith to absolve him of liability, because Derek has voluntarily assumed responsibility of the injury. And the last part is regarding the case here. The case here, nothing much other than the fact that it's just saying that that the defense of section 5 is provided for due to the characteristics, alright, in particular circumstances or whatever it is. So therefore this case here is also relevant to further illustrate and explain section 5. Right, in fact, without the case at all, section 5 by itself should be sufficient already, but because the case is there, right, this case is there, you definitely have to mention it. And if you were to miss it out, then definitely you will not be able to get full marks for it. Okay, so that's about it for this question here.